the August 17th board meeting to order. And Lindy, if you would please call the roll.
Thank you. Director Desmond? Director Frost?
Here.
Director Hume?
Here.
Chairman Riley?
Here.
Director Cerna?
Here.
Director Jennings? Director Kaplan?
Here.
Director Talamentes?
Here.
Chairman Holloway?
Present.
Director Johns? Director Abdis?
Here.
Director Reeder?
Here.
Director Conant?
Here.
We have a 10-member quorum.
Okay, thank you very much. Okay, please join me in the Pledge of Allegiance. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, I believe now we are going to go into closed session.
I'm just going to read announcements real quick.
Oh, sorry.
Good afternoon, ladies and gentlemen. This meeting of SAFCA is being broadcast live and will be cablecast without interruption on Metro Cable Channel 14 on Saturday, August 19th at 4 p.m. Meetings will also be available on SAFCA's website within 48 hours after the meeting. Thank you. And we will adjourn to hearing room 2 for closed session.
Public comment now? Okay. Okay, yeah. So if there's anybody in the audience who would like to speak on any items not on today's agenda, now is the time to do that. None appearing. Thank you. Board back into session, and do we need to do roll call,
Yes, we do.
please?
Director Desmond,
Here.
Director Frost. Here. Director Hume.
Here.
Director Riley.
Here.
Director Cerna.
Here.
Director Jennings. Director Kaplan.
Here.
Director Talamentes.
Here.
Chairman Holloway.
Chair.
Director Johns. Director Avdis.
Here.
Director Lee Reeder.
Here.
Director Conant.
Present.
And we have
Okay.
an
Ms. Goldberg,
11-member
would you like to
quorum.
report out closed session?
Nothing to report at this time other than for the item related to TDW Enterprises, APN 35-170-003. Director Nick Abdis was not in the room and had recused himself.
Okay. And Lindy, would we go to consent matters now and then separate items?
Consent
okay.
items 1 through 9 are in order.
Okay. Anybody like to pull any items on the consent calendar off?
I'll move consent.
Second consent.
Okay. We have a motion and a second. Any further discussion? Please call the roll.
Director Desmond.
Aye.
Director Frost.
Aye.
Director Hume.
Here.
Director Riley.
Aye.
Director Cerna.
Aye.
Director Kaplan.
Aye.
Director Talamentes.
Aye.
Chairman Holloway.
Aye.
Director Abdis.
Aye.
Director Lee Reeder.
Aye.
Director Conant.
Aye.
Motion passes with 11-member approval.
Okay. Would you please call item number 10?
Our first item is a public hearing resolution of necessity number 2023094, authorizing an eminent domain action to condemn certain real property interests for the Reach F component of Phase 4B of the Natomas Levee Improvement Project. Fee, interest, and temporary construction easement acquisition over portions of Sutter County Assessor's Parcel Number 3517091, located at 3175 Sankey Road, Pleasant Grove, California, 95668, property owner AL Property Holding LLC, and noted this item requires a 2/3 or 9-member vote to pass resolution.
Okay.
Good afternoon, Directors. Matt DeGroat, Real Estate Program Manager with SAFCA. So the property I was just mentioned is located on the land side of the Natomas East Drainage Canal, West Levee, in the Natomas Basin area of Sutter County in California. And acquisition of the property is required for the NEMDEC West Levee Reach F component of Phase 4B of the project. So here we have an exhibit that shows the reaches for the project, and this property is located in Reach F. Attachment B shows a cross-section of the construction activities that are going to take place, and One thing to note on this cross-section, it's a bit different than the typical cross-section because this area of the project is lower, the levee is lower here. So some of the activities that are going to take place here include widening the top of the levee and flattening the landside slope, construction of an operation and maintenance road at the landside toe of the levee, and construction of a landside drainage ditch and establishment of a flood control works protection zone. Attachment C just shows where the property is located within the reach of the project. There it is on the left-hand side. And here we have an exhibit, that attachment D, that shows the proposed acquisition areas. You can see in red is the proposed fee acquisition, and that is to construct the levee improvements and ensure that no encroachments or excavations can undermine the integrity of the levee improvements, and also to allow for the proper operation and maintenance of the flood control features to take place. Additionally, there's a temporary construction easement that is proposed, and that is needed for the construction activities associated with replacing the owner's fence line. Attachments E through E3 are the project description and necessity for the acquisition, the environmental compliance documents, and considerations for selecting the mitigation sites, and additional design analysis that took place. On March 7th of 2022, Safeco sent a letter to the property owners advising that the upcoming project will affect their property. On July 21st of 2022, Safeco did send a letter to the property owners advising them that an appraisal was being prepared to purchase a portion of the property and fee. On February 3rd of 2023, Safeco provided a formal offer to purchase the property rights that was shown on the exhibit before, which were fee interest in a portion of the property and temporary rights that are required for the installation of the fencing. On May of 2023, a clarification letter was sent out that clarified the offer, which described those temporary rights as a temporary construction easement, and a value was placed on that. Attachment J is just a diary of the discussions between Safeco's right-of-way acquisition consultant and the owners. And on August 1st of 2023, a written notice was mailed to the property owners advising them that this board would hold a hearing today at this time to consider the adoption of a resolution of necessity to acquire the property rights by eminent domain. So this slide just shows the exhibits that are attached to this resolution. The exhibits for the fee acquisition area and the temporary construction easement. So at this time, we do not currently have any, we don't have any agreements with the property owners, and we haven't been unable to resolve the issues relating to this acquisition and their potential relocation activities. So it's as a result of this, we're requesting that this board consider the adoption of this resolution of necessity so we can continue to meet our obligations to the Army Corps and certify the real estate for construction of the project. And if this board does choose to adopt this item, staff can wait 30 days before we file a complaint with the courts.
Okay, any questions from the board members? None appearing. Okay, open the public hearing. Is there anybody in the public that would like to speak on this item? Welcome.
Good afternoon. Directors of the board, my name is Benjamin Taggart. I'm an attorney for a property owner of this property. This is subject to the resolution before you, AL Property Holding, LLC. Yesterday, we submitted on behalf of the owner our statement of objections and notice that we would be appearing today on their behalf. The resolution before you is deficient under both statute and the state and federal constitutions. As outlined in the statement of objections that was submitted to the board, this proposed fee area to be taken, particularly for the flood control works protection zone, is not required for the project. And for properties south of the Natomas pump station, that that portions of property have not been acquired for that purpose. And when asked about what this is, what the basis for requiring a fee take of this zone is, no justification has been provided. Initially, it was Safeca had pointed to design criteria. It's not there. When followed up on that issue, Safeca pointed to the Army Corps requiring it. The Army Corps only requires temporary construction easements for this particular parcel. So there is no basis for the additional portions of this property to be taken in fee. And that is a critical issue here because there's no apparent public purpose for the taking of the scope that's proposed in the near term or in the long term as Safeca attempts to works on its this project and its goals of achieving 100 and 200-year flood protection. What it appears to be, and why this additional area, these additional portions of properties north of the pump station being taken are problematic, is because it appears to be a form of land banking. And land banking is not a constitutionally permissible purpose for which any agency, Safeca included, can take private property. Secondly, the resolution is statutorily defective because good faith negotiations between the owner and Safeca have not yet taken place on the acquisition of the property. Setting aside the protection zone issues that we've already described and that are detailed in the letter in our statement of objections, the instructions given for the appraisal ask the appraiser to act as if the project does not exist. That is an improper instruction. And it has resulted in a valuation of the property that is significantly less and not realistic. And so that needs to be addressed with a modified appraisal, with correct instructions before this resolution can be heard.
Please sum up as quickly as you can.
That is all. Those are the two issues before you on this resolution. The two defects, they do dovetail with one another, and both need to be addressed before this resolution can be passed. Thank you.
Any questions?
I have a question. Thank you. And I don't know, I can pose this to council. So just so I'm clear, is the objection is to the take altogether or just the fee portion of the take?
The objection is to the fee portion of the take. It includes...
So not the extent of that fee portion of the take, just the fee portion of the take altogether?
The scope of the fee portion of the take that is for this flood control works protection zone, that is improper. The fee portion that relates to the maintenance road and those appurtenant requirements, that is acceptable and in line with what has been taken on property south of the pump station.
Okay, thank you.
Okay, Director Hume.
Thank you, Chair. Mr. Taggart, in your briefs and then also in your comments here today, you referenced land banking. Can you define that for me in the way that it's being used, that it's forbidden?
Land banking would be the acquisition of property it's not for a public project. So here it's not being, while there is this reference to a flood control works protection zone, that is not something that's being required here. This is developable property. It has a tenant with a significant business on it, and the apparent purpose, the banking aspect of this, is to acquire property before it's actually needed for a public project, so it doesn't need to be acquired at a later date for more money.
Okay.
Okay, any other questions for Mr. Patrick? Director Aptis.
All right, Mr. Taggart, can you elaborate on your understanding of what this additional flood control works protection zone is going to be used for?
Neither the owner nor council has a clear understanding of what that flood control works protection zone is going to be used for. It is not clear from our communications with Safeca staff, and it is not something that's contemplated in project documents on this project.
I don't know if staff wants to address that question about what this flood control works protection zone is. It is part of the proposed take, obviously, because it is my understanding that it is part of the core project in Natomas. You know, if you're not getting a satisfactory answer, maybe somebody on staff can address that question, or at least meet with Mr. Taggart after the meeting and provide the answers that he's looking for.
Yeah, why don't we meet after? I think we've discussed it extensively in closed session, so we can meet after and discuss it.
Okay. Thank you, Mr. Patrick. Any other questions from the directors? Okay, thank you. Anyone else in the audience like to speak on this particular item? And do we have any other written communication?
I have not received any.
Okay. All right, close the public hearing. What's the pleasure of the board? That means I like a motion.
I'll reluctantly make a motion. I can tell you all of this is very uncomfortable for me as a board member because I do not feel I have enough information in front of me. And I implore staff to make sure when items like come up, I hear time limitation, but I got to say no excuse when I feel like as a board member I'm making a decision based on insufficient facts. But I'll make a motion to move this, but hold the filing for 30 days to continue negotiations.
Okay, we have a motion and a second. Any further discussion? Please call the roll.
Director Desmond?
Aye.
Director Frost? Aye. Director Hume?
Aye.
Director Riley?
Aye.
Director Cerna?
Aye.
Director Kaplan?
Aye.
Director Talamentes? Aye. Chairman Holloway?
Aye.
Director Avedis?
I have a question for Mr. Johnson. So just to be clear, if we do not adopt this resolution of necessity, it will impact the project schedule for the core project in Natomas. Is that correct?
Yes.
So while I share some of Director Kaplan's concerns, I have no interest in delaying the project, so I will vote aye.
Director Lee Reeder?
Aye.
Director Conant?
Aye.
Motion passes with 11-member approval.
Okay, thank you. Would you please call item 11?
Item 11, resolution of necessity number 2023-095 regarding APN 201-0110-017, property owner DeWitt Farms LLC.
Well, good afternoon, Directors. Matt Dragout, Real Estate Program Manager again with Safeca. So this item, staff does recommend that it's continued for 30 days until the next board meeting.
So continue.
Do you need a motion?
Yes.
I'll move that the item be continued.
Okay.
Second.
Okay, we have a motion and a second. Any
I'm
further?
sorry, who was the second by? Director Kaplan? Thank
Okay.
you.
Any further discussion? Please call the roll.
Director Desmond? Aye. Director Frost? Aye. Director Hume?
Aye.
Chairman, Director Riley?
Aye.
Director Cerna?
Aye.
Director Kaplan?
Aye.
Director Talamentes? Aye. Chairman Holloway?
Aye.
Director Avedis?
Aye.
Director Lee Reeder?
Aye.
Director Conant?
Aye.
Motion passes to continue for 30 days by 11-member approval.
Okay, item 12, please.
Item number 12, public hearing resolution of necessity number 2023-096, authorizing an eminent domain action to condemn certain real property interests for the Reach F component of Phase 4B of the Natomas Levee Improvement Project, fee interest, access, drainage, public road, and public utility easement, water conveyance facility easement, and temporary construction easement acquisition over portions of Sutter County APNs 35280001, 35280007, and 35280010, located at 2905 West Riego Road in El Verdo, California, 95626, property owner Odysseus Farms. This item also requires a 2/3 or 9-member vote to pass resolution.
Mr. DeGroot?
Good afternoon again, directors. Matt DeGroot, Real Estate Program Manager with Safeco. The property just mentioned is located on the land side levee of the Natomas East Main Drainage Canal West Levee in the Natomas Basin area of Sutter County, California. And acquisition of the property is required for the Reach F component, Phase 4B of the project. Here again is the map that shows the project reaches, and this is again in Reach F. Here is a sketch that shows the typical levee improvements along Reach F that you're used to seeing, which include installing cutoff walls, flattening the landside levee slope, and construction of the seepage berm, relocation of conflicting utility infrastructure, construction of operation and maintenance road at the landside toe of the levee, and establishment of a flood control works protection zone. Attachment C shows the location of the property within the reach of the project. And this exhibit, again, it shows the various proposed acquisitions for this property. So first we have a fee acquisition, which is to construct the levee improvements to ensure that no encroachments or excavations undermine the integrity of the levee improvements and allow for the proper operation and maintenance of the flood control features to take place. There's also an access, drainage, public road, and public utilities easement needed, and that's needed to relocate the facilities outside of the project footprint. This property also has a water conveyance facility easement that's needed, and it's needed to relocate the Natomas Central Mutual Water Company's Montana East water conveyance facilities outside of the project footprint. And finally, there is a temporary construction easement that is required to replace the fence and reconstruct the owner's irrigation canals and berms. So again, here's attachment E to E3 of the staff report, which describes the necessity for the acquisition, environmental and compliance documents, and considerations in selecting the mitigation sites, and other analysis that was done. On March 7th of 2022, Safeco sent a letter to the property owners advising that the upcoming levee improvements will affect their property. On December 10th of 2021, and with updates later sent on June 29th of 2022 and March 10th of 2023, Safeco advised the property owners that an appraisal was being prepared to acquire the required property rights that we just saw on the previous slide. On June 9th of 2023, Safeco did provide a formal offer to purchase those required property rights that were shown on that previous slide. And attachment K is a diary of discussions between Safeco's right-of-way consultant and the owners, during which they discussed the project and the acquisition process. On August 1st of 2023, a written notice was mailed to the owners of the property advising that the board would hold a hearing today at this time to consider the adoption of a resolution of necessity to acquire these property rights by eminent domain. So this property is represented by council, like the other one, and at this time we have not been able to reach an agreement on terms of the acquisition. So we're here today to ask the board to consider this resolution so that we could meet our obligations to the Army Corps and provide the certified real estate necessary for the project construction. And if this board does choose to adopt this, Ron, staff can wait an additional 30 days to file a complaint with the courts.
Okay, thank you very much. Any questions from the board members? None appearing. Okay, open the public hearing. Do you have members of the public would like to speak on this item?
Benjamin Taggart appearing on behalf of the property owners. Just as with item number 10, Odysseus Farms filed yesterday notice to be heard and a statement of objections. The objections are the same because the flood control works protection zone is also being taken on this property north of the pump station. That zone has not been taken south of the pump station. 20 miles of levee, more or less, have been completed, and that project, that new piece of the project has not been taken in fee. It is not required by the Corps, and speaking to some comments by the directors in hearing item 10, this board has an independent obligation to conduct oversight of the agency. It requires sufficient information. Adopting a resolution of necessity is a quasi-judicial function of this board. And if you're not proceeding with adequate information to make an informed decision on whether or not to take a private property from a person, however it might be held, that is a derogation of your duties in that oversight role. A resolution cannot be accepted without sufficient information to make that informed decision. And it appears that at a minimum, that information is not present here. And the flood control works protection zone, the purpose of that fee, that portion of the property that's being taken in fee, that has not been addressed. That might be addressed afterward, but it has not been addressed prior to this resolution being heard and voted on. And speaking to Director Advis, there was a question about whether or not the resolution needed to be adopted today or the project would be delayed. Well, item number 11 was continued for 30 days without a vote. What is the harm in sending the resolution back to staff so that these issues can be addressed, so that sufficient information can be put before the board so it can make an informed decision on whether or not these defects, these constitutional statutory defects, are legitimate, whether or not staff is indeed engaging in good faith negotiations with property owners all along the levee, north and south of the pump station, to make sure that everyone is being treated equally and their rights being respected. The issues on this resolution are the same. The problems here are an apparent attempt to bank land and an absence of good faith negotiations because of improper appraisal being put forth by safety staff. That's all.
Okay. Thank you. Okay, questions of Mr. Patrick. Director Desmond.
Thank you, Mr. Chair. I'd like staff to actually address that point that council raised. I mean, yes, we continued action on item number 11 for 30 days, but the advice you're giving us here is that that would not be appropriate for these other two RONs. Rick, can you explain that?
Well, I'm debating how much to talk about from closed session because we explained why we were wanting to do the other for 30 days. Well,
I think it's important that we do get some public response because it is an issue that has been raised in the public hearing.
Because they had given us a counteroffer, we felt we could reach resolution on it. That's why we wanted to extend it for 30 days.
Thank you.
Okay, any other questions?
Chair?
Yes, Director Hume?
Yeah, I have a question, and it's not of the speaker, but just the discrepancy between north of the pump station and south of the pump station. Can you speak a little bit to that as to why there might be two different standards?
John, you want to help me on that one?
Since July of 2009, the flood control works protection zone has been in every resolution of necessity that this board has adopted for the Natomas project. So I think Mr. Taggart has his facts incorrect.
So there's not one standard north of the pump station and a different standard south of the pump station?
There's, each area of the project has
Sure.
its own requirements.
Sure.
There was sufficient flood control protection buying the fee in the area south of the Natomas or NEMDC stormwater pump station, which is on East Levy Road. We had sufficient rights in Reach H and Reach I where we bought fee. We didn't have a whole lot of resolution necessities in that area, so that item didn't come up really. In Reach A, Reach B, Reach C, and Reach D, again, since July of 2009, this same issue, one of the components of the flood control works protection zone, if not wanting to go back, but the exhibit that was included in item 10 shows a vegetation-free zone, a vegetation management zone, and other requirements. Those are part of the Corps' requirements for SAFCA to operate, maintain, repair, rehabilitate, and replace the project. The fee area, keeping unwanted vegetation out, keeping excavations out, which are all explained in the staff report as to what that flood control works protection zone is being used for. It's to keep encroachments and other excavations from undermining the integrity of the levee. That is something that the board is held to under the PPA, Project Partnership Agreement, and the local project partnership agreement over the life of the project, not just the Corps' construction, but from now until, 100 years from now, your board signed up to protect this levee, and that flood control works protection zone is needed to do that. It's not a land banking for a future project. It is for the project at hand.
Thank you. That was a much more thorough response than what I was actually asking about, but I'm happy to have it. So with that, Chair, I'd move the item.
Great response. Okay, any other questions of either staff or Mr. Patrick?
Yeah, I have a couple of comments. So, Mr. Bassett, actually, thank you for that explanation. Mr. Taggart, do you have any response to that? Because it sure does appear that this additional area that you're referencing is part of the project, as you just heard from Mr. Bassett. So, do you have any response to that? I mean, this is a pretty serious question. I mean, obviously, the power of eminent domain is an immense power exerted by government, and it should be done thoughtfully and as narrowly as possible. Obviously, the greatest public good for the least amount of private or impact. So this is an important line of inquiry here, and I'd like to know, from your perspective, do you have any, not to put you on the spot, but you've obviously have spent quite some time tooling around, in fact, probably more so than many of us, into the bowels of eminent domain law and justifications for the rights to take. So do you care to respond?
To Mr. Bassett's point, as was pointed out in the statement of objections, we have been in communication with staff on the purpose of this zone. This additional fee take and why it was being taken in fee and not some kind of easement interest being taken. Mr. Bassett's description of the use of that area, keeping vegetation out, et cetera, that conforms with the Corps' responsibilities and the Corps' requirements as a project partner. But the Corps only requires easement interest to be taken. The question is why this is being taken in fee, why that additional slice of land is being taken in fee, and that, even with Mr. Bassett's detailed explanation, has not been addressed. And as I mentioned during my comments on item 10, the response initially was that it was allowed or required by the design criteria that govern the project, and that's not the case. When followed up, the response was pointing to a core requirement. And again, the core requires easement interest to be taken, not the fee interest.
So is that the core of your contention here, that this should not be a fee acquisition, it should be an easement area acquisition?
Yes, at a minimum, it's recognized that the project has needs beyond what is being taken in fee.
So, okay, so then it's a question of valuation then, not about the government's ability to obtain a property right in this area that, we can disagree about whether a fee interest or an easement interest. It's still, property right that's being taken, and it's really about the valuation at that point. Is that correct?
The area being taken, the total area being taken in fee is at issue. It is at issue for the owners in both of these properties. And in what has been provided to the owners and council, does not appear that the area proposed to be taken in fee for the flood control works protection zone is required to be taken in fee. It is dovetailing with that. It's not clear whether that entire zone would be necessary for easement rights.
So I appreciate that. I think the position you're asking this board to take in terms of delaying this for additional discussions, that, that's obviously going to be problematic in the project schedule. We can't, we obviously appreciate the property rights people have, but we also have over 100,000 people that live in Natomas that are counting on this project to get done on time. And so, this is, again, an unfortunate circumstance for this board to be in, where we have to make decisions like these, but that's why we get put here. It sounds like to me that this is a question of valuation, not one of need. So, obviously you have the right to exhaust your legal remedies, obviously on the right to take, but obviously I would encourage, staff and the property owner in terms of figuring out a resolution to avoid such litigation.
Okay, any other questions?
I want the same motion on this one to be held for 30 days.
I need to close the public hearing. So do we have any other members of the public that would like to speak, or any other written communications? Not appearing. I'll close the public hearing. And what's the pleasure of the
We have a motion by Director Hume.
Director Hume, would you add the friendly amendment that it's the same motion that applied to item 10 of holding the filing for 30 days to continue negotiations?
That's fine.
Okay, we have a motion and a second. Any further discussion? Please call the roll.
I'm sorry, I didn't get the second.
Kaplan.
Okay, thank you. Director Desmond.
Aye.
Director Frost.
Aye.
Director Hume.
Aye.
Director Riley.
Aye.
Director Cerna.
Aye.
Director Kaplan. Aye. Director Talamentes. Aye. Chairman Holloway.
Aye.
Director Abdus.
Aye.
Director Lee Reeder.
Aye.
Director Conant.
Aye.
Motion passes with 11-member approval.
Okay, please call item 13.
Item number 13 is a public hearing resolution of necessity number 2023-097 regarding APN 35170044. Property owner, the Stevenson Family Trust, dated November 7th, 2005.
Good afternoon, directors. Matt Turgot again with Real Estate Program Manager, Safeco. And staff for this item does recommend this item is continued for 30 days until the next board meeting.
Okay, thank you very much. Okay, is there any public comment on this item before we do that?
I have not
None
received
appearing?
any.
Okay, we have a motion and a second. Please call the roll.
I'm sorry, I got a motion by Director Cerna and the second, Director Desmond. Thank you. Director Desmond?
Aye.
Director Frost?
Aye.
Director Hume?
Aye.
Director Riley?
Aye.
Director Cerna?
Aye.
Director Kaplan?
Aye.
Director Talamentes?
Aye.
Chairman Holloway?
Aye.
Director Abdus?
Aye.
Director Lee Reeder?
Aye.
Director Conant?
Aye.
Motion passes to continue for 30 days with 11-member approval.
Thank you, Mr. DeGroot.
Item number 14, public hearing resolution of necessity number 2023-098, authorizing an eminent domain action to condemn certain real property interests for the Reach F component of Phase 4B of the Natomas Levee Improvement Project, fee interest, electrical and communication facilities easement, and temporary construction easement acquisition over portions of Sutter County APN 35170-003, located at 7203 Natomas Road, Alberta, California 95626. Property owner TDW Enterprises LP. This item requires a 2/3 or 9-member vote to pass resolution.
Mr. Chair, I need to recuse myself from this item, and I'll be exiting the hearing room.
So noted.
Okay.
Good afternoon, directors. Matt DeGroat, Real Estate
afternoon.
Program Manager.
Welcome back.
Safeco. Hello again. So the property I was just mentioned is located on the land side of the Natomas East Main Drainage Canal, West Levee, in the Natomas Basin area, Sutter County. And acquisition of this property is required for the NIMDEC West Levee Reach F component of Phase 4B of the project. Again, here's attachment A that shows the project reaches, and this is part of Reach F. Attachment B is the typical sketch again that shows the levee improvements along Reach F, which include installing cutoff walls, flattening of the landside levee slope, construction of seepage berms, relocation of conflicting utility infrastructure, construction of operation and maintenance roads, and on the landside to the levee, and the establishment of a flood control protection work zone. Attachment C shows where this property is located within the reach. And here we have an exhibit that shows the proposed acquisitions. So on this property, there is the proposed fee acquisition, which is to construct the levee improvements to ensure that no encroachments or excavations undermine the integrity of the levee improvements and allow for the proper operation and maintenance of the flood control features to take place. There is also an electrical and communication facilities easement that's required, and that is needed to relocate the existing utilities out of the footprint of the levee improvements. Again, there is a temporary construction easement that is also being proposed, and that is required for construction staging and also for the installation of the fence line. Again, attachment E33 is the project description and necessity for the acquisition and environmental compliance documents and considerations in selecting the mitigation sites, and additional design analysis that took place. On March 7th of 2022, Safeco sent a letter to the property owners advising that the upcoming levee improvements project will affect their property. On June 28th of 2022, and then updated on January 10th of 2023, Safeco sent letters to the property owners advising them that an appraisal was being prepared of the property to acquire the required property rights that were on the previous slide. On May 24th of 2023, Safeco did provide a formal offer to purchase the property rights that are required for the project that were also shown on that exhibit. Attachment J is a diary of discussions that took place between Safeco's right-of-way consultants and the owners, and describing the project and the acquisition process that would take place. On August 1st of 2023, Safeco mailed a written notice to the property owners advising them that this board would hold a meeting today at this time to consider the adoption of a resolution acquiring the property by rights eminent domain. A resolution of necessity to acquire the property rights of eminent domain. Sorry. And here we have the exhibits that are going to be part of this proposed resolution. And again, so this property, like some previous properties of the project, is part of a larger ownership group that is interested in developing the area. And similar to those properties, we have not reached an agreement on the details of this transaction. So it's for this reason that we're bringing this motion for you today to consider the adoption of this resolution of necessity so we can, again, continue to meet our obligations to the Army Corps of Engineers and provide the real estate required for the project. And like the previous resolutions, staff can, again, hold 30 days to file a complaint with the courts on this. Thank you.
Okay. Thank you very much. Okay, questions from board members? Okay, none appearing. Open the public hearing, and do we have anybody in the public, any public representatives that would like to speak on this item or any other written communications?
I have not received any.
Okay, all right. Close the public hearing, and what's the pleasure of the board?
Move approval of the resolution.
Okay,
Friendly amendment to codify that we do agree with the holding it for 30 days for negotiations.
okay,
Looking at council. Okay.
acceptable? Okay, all right. Motion and a second. Any further discussion? Please call the roll.
Was the second Director Talamentes?
No.
Desmond, sorry. You don't sound
He
like her.
sounds a lot like
You don't sound like
Talamentes.
her.
I heard one somewhere.
I can't hear. Okay. Roll call. Director Desmond?
Aye.
Director Frost? Director Hume?
Aye.
Director Riley?
Aye.
Director Cerna?
Aye.
Director Talamentes?
Aye.
Director Holloway?
Aye.
Director Abdus? Recused himself, Director Lee Reeder?
Aye.
Director Conant?
Aye.
Thank you.
Okay.
Motion passes with 10-member approval, pending a
thank
hold
you.
for 30 days.
All right, Executive Director's report, receive and file, and any other further business come before the board today? We are adjourned.